Okay, I think we'll go ahead and get started. I know several folks are still logging in, but just thought we would hit this right on time because we have a lot to cover today. First of all, thank you so much for giving us your time. I know that a lot of people are Zoom called out given the environment that we're all living in, and so we really do appreciate you taking some time to learn about what we think is a really exciting and groundbreaking opportunity in the insurance market. I'm Mary Guzman. I'm the CEO and founder of Crown Jewel Insurance. I've been in the insurance industry my whole career. I started when I was 12, and I have 30 years of brokerage experience before starting this company. And I am really excited to be joined by three other folks today. I'm sorry that Christina's picture is not up here for you, but Christina Dautrick Reynolds is a managing partner with Alvarez and Marsal in the international tax practice, and she's here to share some of her insights about tax strategy regarding trade secret assets specifically. Phil Antoon is a managing director with Alvarez and Marsal also, and he runs the valuation group. And we've been working together really for a couple of years or longer than that on trying to figure out a way to value these assets in such a way that it's meaningful for insurance underwriters to get their arms around and for clients to understand what they're buying. So Phil, thank you for being with us. And then Mark Halligan, also known as the Nutty Professor, is a partner with Fisher Broyles, and he's been doing trade secret litigation for a very long time, and he teaches trade secret law. He also was just named Best Trade Secret or Intellectual Property Lawyer of the Year. And so we are thrilled to have him on board with us as well. Mark, can you look into the camera and say hi?
Hi, everyone.
We see you from the side again.
Oh, you do? Okay.
Yeah, there you go. Thank you, Mark. And with that, I think we'll get started about what we're doing here. Gail, thank you. So first, we wanted to just kind of level set and identify the problem for everyone on the phone. And I think for those of us who have lived in the cyber world, which is where I spent really the last 15 years of my brokerage career focused on cyber, media, and intellectual property related risk for large organizations and trying to develop products and services that were meaningful to clients who were concerned about intangible assets as much or even more so than tangible assets. And so as part of that learning experience, for me, in my former role, I came to realize that a lot of organizations don't really understand the value of their trade secret assets, although intuitively they know that they have them and they know they're important, which was really surprising to me. But I think there are a lot of reasons why that's the case. First of all, they're not carried on public company balance sheets unless they're specifically called out as part of a valuation during an acquisition. So homegrown trade secrets, which are the case most of the time, are not typically recognized as they grow and grow in value over a period of time as they become more valuable to the organization. Such things could be improvements in processes. They can be technologies, designs, drawings, things like speed to market. Your logistics and supply chain functions can be valuable. So we're not necessarily talking about things that sit within your R&D group, but anything that your organization is keeping secret because it's a competitive advantage for you that's in the form of designs, drawings, recipes, all of those types of things can be considered a trade secret. So a lot of organizations will have these valuable assets sitting right underneath their nose, and they've never essentially either identified or quantified them. So unless a company is trying to sell itself, the whole company, or parts of itself, its technology, a lot of times that valuation process is never done. And another reason that we think that organizations kind of skip over that is that it takes a fair amount of work to develop and organize a trade secret asset management program. We're going to use a couple of acronyms when we're talking about this today. One is automated TSAM, which is Trade Secret Asset Management, and the other one is TSARM, which is Trade Secret Asset Risk Management. And those are different, and we'll tell you why we think those are different and what each of those things are as we move through this presentation today. One other reason is that I think, certainly senior executives and boards of directors have known or felt that trade secret assets were not insurable from a first party standpoint, and they really haven't been up until now. And so if you can't buy insurance around them, but then maybe, I don't know, maybe it's not worth the trouble in some people's minds of going through the process of identifying and valuing and throwing a bunch of additional assets at those, although I would argue that certainly it needs to be part of any ERM program. And then finally, directors and officers for public companies have been able to use the prudent person rule for several years now. That goes back decades now, around the protection of data or other decisions that they make internally. But that protection around, or excuse me, that prudent person rule to apply around the protection of intangible assets has been being eroded over the last few years, as far as personally identifiable information, credit card, health information on the cyber side. So it stands to reason that there's going to be some implications in the future, in the not too distant future, about corporate confidential data, which would include trade secrets.
Mary, if I could make one quick comment here, going back actually to the first bullet. If you go way back to when I first started conducting valuations, when you looked at the value of public companies, intangible assets really weren't that widely recognized in the fair market value of the public companies. So you could look at the market value of a public company, and then when you looked at the net book value of the equity of that company, it's probably a ratio of 80% of the net book value to the fair market value. So there really wasn't, and I'm not just talking about trade secrets here, we're looking at patented technology, trade names, customer relations. Think about any intangible asset. So fast forward to today, different dynamic, yes, because we have so many high-tech companies, but if you look at it now, companies and markets have come a long way in recognizing the fair market value of intangible assets in their overall market capitalization. So just an important jumping off point, going from the assets weren't even recognized for the most part in value to now today, the intangible assets comprise a significant portion of many companies' value.
Yeah, absolutely. That brings up another good point, which I'll mention really quickly. We feel like this whole process of the insurance and everything that we're talking about today could be particularly valuable for private equity companies because, as Phil was just saying, a lot of times private equity companies invest in, portfolio company for their intangible assets, for their ideas, their drawings, their designs, the business processes they use that make them better, faster than their competitors. And if you can only require that those portfolio companies buy regular, kind of state of the market property, general liability, workers' comp, maybe cyber, some E&O thrown in there, some D&O, none of those policies cover the value of the underlying asset or assets, which were the reason you invested in that company in the first place. And so for private equity companies, this type of insurance could be a game changer because it's the first time those assets can be insured from a first party standpoint. We'll talk about that a little bit more in just a second. Thank you, Phil. So what we're trying to get people to do is think about trade secrets as a strategy, meaning that a lot of organizations, it seems, when we first started talking to people, and to Phil's point, I think Mark would agree with this as well, and several of the attorneys that are on the line here, a lot of organizations sort of seem to view having their technology patented as the holy grail and pursue that with vigor. And I think perhaps that's because there was a perception, which may have been mostly true until a few years ago, that patenting your technology was the best way to protect it from your competitors. But given what's happened in the last few years, and particularly since 2016, when the Defend Trade Secrets Act passed, now there's a federal statute and a federal way to protect your trade secret assets, such that you might actually consider leaving things in their trade secret form rather than patenting them for a host of reasons. But we'll get to that in just a second. But really what we want organizations to do is, if they're not already doing it, is talk to their legal advisors and their accounting firms and other outside consultants to the extent that they need to figure out how they're going to treat individual assets and why they might want to leave something as a trade secret. So first you look at monetization, which is something that a lot of organizations haven't been doing, as Phil was just talking about, where you've identified a business process as something that's critical to your organization that makes you able to deliver your products and services on average 2 minutes faster than your competition, times however many drivers you have in the field, times however many days in the year. That ends up being lots and lots of money if you're a big logistics and supply chain company, for example, or a manufacturer. So that process could be valued as a trade secret. If you effectively quantify that trade secret as an asset, now you can carry it on your balance sheet, which is huge for a lot of organizations, especially, frankly, mid-size organizations coming out of this pandemic who might be strapped for cash and might need to seek alternative financing or funding mechanisms that they can only do by showing that their balance sheet is better than it looks without these intangible assets showing, is something that's actually valuable to them. So the thought of just giving it a strategy on whether or not you need to monetize those assets, and regardless of how you treat them at the end of the day. Taxation is really important. Christina's going to talk about this a little bit further on another slide, but aligning your tax and operating strategy to maximize the benefits of your IP both in the US and internationally is really important. Protection, what's the best way to keep your crown jewels protected, and not just from a technology standpoint, which is what we're used to thinking of in the cyber arena most of the time, but from a contractual perspective, and understanding what's happening around the world in terms of trade secret law and your ability to keep those secrets, well, secret. Is that a better way to protect those assets than filing for something with the USPTO, where the minute you do that, it becomes public information? So that's another consideration. And then finally, if you keep these assets as a trade secret, that we can value them now, and we have an independent third party to do that, that's trusted by the underwriting community. And once we do that, we can insure those assets under this program, which is something that from a first party standpoint, you can't really do. Well, I know you can't do it from a patent portfolio perspective, because that information is by definition not secret. So it's another arrow in the quiver and another thing to think about. And then finally, how will your stakeholders view these decisions? Down the road, could directors and officers be facing litigation in the form of lawsuits following a significant stock drop that's the result of an acquisition that doesn't go through because trade secrets get stolen, or a conflict between you and your largest competitor that takes litigation out years and years and spends millions of dollars that wasn't funded. So another thing to think about. So to patent or not to patent, that's one of the things that we were talking about on the previous slide. And essentially, as discussed, as soon as you file for something with the US Patent and Trademark Office, there's an awful lot of detail that you have to provide in order to get approval for a patent. And so as soon as you do that, what was a trade secret 5 minutes ago before you hit the send button is now no longer a trade secret. It literally goes to zero value from a trade secret standpoint as soon as it becomes not secret anymore. And that's something that I think is lost on a lot of people, that most things in your R&D, supply chain that are sort of becoming more valuable over time, that can be pharmaceuticals, it can be chemicals, it can be all kinds of different technologies. Those are trade secret assets that become more and more valuable over time, but as soon as you file for a patent for those, they lose their value as a trade secret asset. That's not to say that you should never patent anything. Certainly, I'm not here to argue that. at all. It's just that you need to be thinking about that as a strategy, because at that point, really your only recourse against the theft or essentially misappropriation or infringement of that asset is to sue someone for patent infringement, which is extremely time consuming, costs a lot of money, and isn't always successful. And so that certainly needs to go into the strategy. The other thing that's interesting about this DTSA that we were talking about before is that there's not only the potential opportunity to seek compensatory damages, but there's the potential to get treble damages or multiple damages because it was written right into the DTSA, and Mark can share a little bit of additional insight on that. But so that means there's a chance that not only will you get, kind of the base compensatory damages back, but you can get effectively what looks like punitive damages under the DTSA, which is, again, not something that you're going to be able to pursue necessarily once you've patented information. Next slide, please. So now that we know what the problem is, and that we know that trade secrets can be protected because of the 49 state laws and now the DTSA in the United States, then we have to decide, once we've identified and valued those assets, how we're going to mitigate the risk around those assets and transfer some of the exposure. So this is really just meant to highlight these are risk management fundamentals no matter what asset you're talking about within an organization. First, you identify whatever the risk is. It's either an asset or a peril, could be on the liability side, but you identify what that is. You try to quantify what the exposure looks like. Then you, from there, only after you've done those two things, which is really important, then you can start to develop a risk mitigation strategy or loss control, loss prevention, disaster recovery, business continuity, a lot of different ways to skin that cat or describe it. But it's all the protections, legal, contractual, physical, all of those types of things that you would put around a particular asset to mitigate the exposure to whatever the peril is that you're trying to insure against. Then you transfer to the insurance market or to a third party if you can. And then ultimately you're trying to recover and make sure that the loss isn't a total loss or isn't just as bad as it possibly could be. So not only will you not succeed essentially in trade secret enforcement litigation without a risk management process in place, but you won't be able to insure or borrow against these assets. So this is an absolutely critical thing to get your mind around in terms of having these steps in place before you even consider seeking enforcement litigation, or else, as we will speak to a little bit more later, one of the biggest problems that organizations face today is throwing a lot of money straight at risk mitigation, implementing a lot of security tools and policies and procedures, but throwing them equally at all kinds of different assets, waiting for a potential asset or whole group of assets to be stolen or misappropriated, and then sending attorneys in to do a very lengthy discovery process to try to, going backwards, identify what they now think was a trade secret. And the judges are not having it. Essentially, if you read a lot of the litigation or the settlement and the cases that are posted all the time in intellectual property litigation, the judges are really coming down on organizations for trying to do this backwards. And that's what we're trying to help organizations prevent here. Next slide. So one of the things that a lot of people ask, which we'll address quickly, is there insurance coverage currently for trade secret misappropriation? And the short answer is no. You can read this slide in a little bit more detail, but essentially, property policies have never really adequately covered intangible assets. They don't insure the value of data for the most part, so you can kind of take that off the table. You might get some business interruption coverage for a DDoS attack, a virus, a worm, some other cyber-related issue, but and the cost to recreate data, but not the data itself. Cyber policies do cover data. I think everybody knows that by now. And they even cover corporate confidential data, which could be a trade secret. It could be copyright, trademark, a lot of other things. The challenge is in the valuation clause, and that is that every cyber policy in the world essentially will say yes, we cover the theft of corporate or disclosure of corporate confidential data, but again, we're not going to pay you for the value of that data because we didn't pre-agree on what that value is, number one. Number two, we think that it would be a huge dispute if we tried to, look back now and figure out what the value of the data was, because you, Mr. Insured, are going to think it's much more valuable than we do based on future sales, which are very difficult to insure, and future income is essentially never insured under most of these policies. So that's another reason why the cyber market hasn't done that. The valuation is a problem, and adjusting the claim would be a problem. And then finally, there are some intellectual property policies in the market that cover patent infringement and trademark infringement and other things, but those are mainly third-party policies, meaning your organization is being sued for alleged infringement of somebody else's intellectual property assets, not going the other way around. So this is the only policy that we know of that actually covers the fair market value of the assets that you're trying to protect from a first party standpoint. And then to the extent that there is the need for litigation or subrogation on the back end, as the case may be, whichever enforcement mechanism we need to trigger with Mark's help, the policy will then turn around and act as an offensive policy to try to go after that third party, and it pays to fund the litigation on the back end. There is one other policy in the market today that talks about some limited trade secret coverage, but our understanding is that policy, the claims will still be adjusted as though it's sort of like a future business interruption loss, which again means there's going to be a lot of argument back and forth on, did you actually lose the full value of that asset based on the fact that, between the time you bought the policy and the misappropriation occurred, two other competitors entered the market with something really similar. And so we as the carrier are going to argue that you wouldn't have gotten the market share you thought, and so the fair market value was wrong in the first place. There are a lot of challenges, I believe, and I think we all believe, and that's why we approach this differently with doing something that way, and that's why we didn't go with that approach. Next. And I will let other people talk, I promise. So announcing Crown Jewel Protector, yay. That is the program that we put together that is essentially what we're calling, it's everything from pre-bind to post-breach. It's risk mitigation and identification and valuation on the front end, where we'll be using the brilliant minds of some of the people on the phone or on the computer here to help us figure out how to value these assets. Something really important that we're introducing as part of this that frankly was critical to getting the underwriters comfortable with this risk is something called the Trade Secret Examiner, which is an automated TSAM tool. We talked about that a little bit earlier. It's a software platform that's blockchain, and Mark was one of the co-founders of this software platform. And essentially what it does is allows an organization to, where it ranks for them, the protectability or defensibility of any given asset as a trade secret using well-known tests in the litigation world around whether or not something qualifies as a trade secret asset. So there's a 6-factor litmus test and the IONA principles, which Mark will talk about when we get to the case study in a little bit. But essentially, it allows an organization to share that software with a number of individuals internally to input the data about how much time and energy they've spent on a particular product, how they're protecting it, who has access to it, how it's labeled, what their non-competes say within their employee and contractor segments, and all of those types of things, and will ultimately help us to determine whether or not something is defensible as a trade secret and therefore insurable in the market, or how defensible something is. But it also then, when we have to litigate or use our enforcement strategy later on, will be a perfect piece of evidence that we can take into court to try to get an ex parte seizure order or temporary restraining order, so that even if the trade secret has left the building, so to speak, we can recapture it before there's too much damage done, putting the genie back in the bottle. So that's a really important feature. We also are adding dark web monitoring, which any of you who are familiar with cyber insurance would know that a lot of organizations now are offering dark web and dark web monitoring as a service, but in this case, we're looking specifically at the trade secret assets that we are scheduling on this policy. And then finally, again, after the insurance is triggered and assuming that we pay the fair market value of an asset that's gone missing because we were not able to recapture it at the ex parte seizure or temporary restraining order phase, then we will pursue third-party litigation on the back end using Mark's expertise together with the intelligence community, whomever it is that we need to involve from a legal and intelligence perspective. We will certainly do that. So this, again, is meant to be a, hey, if you're an organization that has a lot of patents or a lot of information in R&D, because if you have a lot of patents, you probably have a lot of trade secrets, patents in the works, if you will, then this is meant to sort of be dropped in so that you can say to yourselves and to your board of directors, hey, you know what, we've got a formal process to identify, quantify, value, and mitigate exposure to all of these assets. And by the way, we bought insurance if they still go missing anyway. Next. Automated TSAM. This is something that Mark likes to talk about. This is a little bit different than the risk management approach that we talked about earlier. This is really kind of step one of the TSARM process, bleeding into step two, which is identification. In my terms, just general risk management terms, identification and valuation, those two stages. But if you talk about looking at trade secret assets in particular, you have to look at breaking that down even further into this particular order, and it absolutely has to go in this order. And again, to make the point here that it's really hard to do a good job protecting your data and to be able to show a judge or a jury that you did a good job protecting your trade secret assets if you haven't even identified or classified them as trade secrets, essentially, before a loss occurs. And so the reason we're showing self-evaluation here, just by the way, is because the trade secret examiner, which helps us do this, does allow for the client to put in a lot of information, populate data that will give us some sense of the value of that asset as perceived internally by the insured organization. But we certainly still need and want an independent third-party valuation by experts in their field, which is where Phil comes in. Next slide. The trade secret examiner, as we talked about a little bit earlier, uses blockchain. It's a game changer in the industry. It's automatically included with the insurance as long as the client buys at least $10 million in limit. And that's the only reason for that is that's where we kind of figured the price point would be where we could roll that into the overall cost of the premium without having it be too exorbitant for us to handle. But we absolutely believe this is critical to the whole thing, if for no other reason, well, for lots of reasons, but on the front end, it helps you identify and value your trade secrets and look at yourself internally and see how you're managing those trade secrets using the litmus test and the IONA principles. But also, it will allow us to have a much better likelihood of succeeding during litigation on the back end because we won't be going in after the fact to try to identify what trade secrets we think someone stole and whether or not they were in fact trade secrets. Next. I think most people know by now what the benefits of blockchain are, but essentially, the blockchain on this platform supports the metadata so that there's no possibility of the records being altered or falsified, which again gives us the proof of evidence that we need to go into court and show that we have ownership, notice, and access, or that the person who misappropriated the asset had access to that asset, which is the IONA principles that Mark will talk about. Next. This is where Phil comes in.
Can you value a trade secret? And Mary pointed out earlier on that when we first started out with this product, in my mind, the biggest hurdle was, can you value a trade secret? You really needed to get the carriers comfortable with that understanding. So we did spend quite a bit of time with the carriers explaining how and why we value trade secrets, and got them to a comfort level that the answer was absolutely yes. So I'm not going to try to make everybody experts in valuing trade secrets or intellectual property. My goal here in the next few slides is really just to provide support that we do in fact value trade secrets regularly. There are accepted methodologies for valuing trade secrets. And if you look at some of the reasons we value trade secrets outside of trade secret insurance, financial reporting. So anytime there's an acquisition, companies have to record the fair value of the acquired assets on their balance sheets, and trade secrets could be one of those assets. Tax purposes. It could be a function that we are, Christine is involved and she's doing tax planning for international tax planning. All of a sudden, we may be aligning our trade secrets with our operations and therefore moving it from one jurisdiction to another. That requires a fair market value of the trade secret. So we're doing these valuations on a regular basis. There is full support for these valuations, and really just want everybody on the webinar here to have a comfort level that the valuation portion of this is not going to be an issue relative to the overall process. Next slide, please. Thank you. So trade secrets, how do we value trade secrets? If it's an income generating trade secret, you're generating revenue, you're generating cash flows, we have to value it, and we'll value it on a form of income approach. What's that mean? It basically says over how many years you generate revenues and cash flows from this trade secret, and we're capturing the value based on those future income generating capabilities. Key inputs would be obviously the revenue attributable to the trade secret, the life. So many trade secrets have some finite life. Many have a very, very long life. I always use the example of specialty chemicals where they don't patent their formulation because nobody can figure out how they got there. How long do I heat it for? At what temperature? If you don't release those in a patent registration, nobody will know. Those trade secrets could go on for an indefinite period. So life of the trade secret is important, obviously the cash flow. So we're using some form of an income approach. It could be some type of discounted cash flow. It could be a function of what type of license arrangement would one enter into, and therefore what type of royalty rate would one generate. It's really facts and circumstances driven, but I think the key point that everybody should take away here is that if you're valuing a trade secret that is generating income or is going to generate income in the near future, some form of an income method is going to be appropriate. If you do not use an income method, if you use a cost approach, which I'll touch upon next, you're going to end up essentially missing a lot of the value inherent in the trade secret. Another approach, cost approach. The cost approach is for earlier stage companies or trade secrets that are in earlier phase of development. They're not generating any income now, but they very likely will in the future. Or it could be a function that they're providing a cost savings to the company. This trade secret is improving the process. And yes, it's not directly generating revenues, but if I didn't have this trade secret, my expenses would be increased by a certain amount. Here's how much it would cost to replicate the cost to develop that trade secret. We use this approach frequently with earlier stage companies where they may be a couple years off from generating revenues, not uncommon. Now, what are we looking at? We're looking at the cost to build up the trade secret to the point that it's currently at. So you're looking at all the hard and soft costs that were expended. And Mark always reminds me to mention negative know-how. What is negative know-how? Well, in developing the trade secret, I took 5 wrong turns, but having taken those wrong turns led me down the correct path. So when you look at the cost to replicate a trade secret and a cost approach, you do want to consider negative know-how. You want to consider those wrong turns that you took. Now, if you took wrong turns and decided, I want to do something completely different, then you have to take a close look as to whether or not they should be incorporated. But if you're dealing with, I took 5 wrong turns and I would have never been where I am without those wrong turns, that's negative know-how that should be considered in the cost to replicate or rebuild the trade secret to its current form. So looking at methodologies again, income approach for income generating assets, cost approach in the situations where it's not yet generating any type of income, but will in the future. And one of the note here, a bit of a side note, is I think you're all going to start to notice a trend in the marketplace of companies using the term data monetization. And we're starting to get questions from companies, seeing inquiries come out. And what is data monetization? How does it factor in here? It's twofold. It's internal. Companies are starting to measure their employees based on productivity and efficiency measured in part by data. So that's one. Two, companies are realizing I have phenomenal data that I've developed internally. I'm going to go out license that to a third party. Or I'm going to use that, to Mary's point earlier, to bolster the value of my company. But many companies are looking at data monetization and they're trying to take data they have generated, the trade secrets, and essentially figure out how to maximize the value of those trade secrets, sometimes above and beyond the normal course of their own operations. You could develop trade secrets that have applications in a different field, and you can generate a license fee for that. Next slide, please. Misconceptions, rules of thumb. Anytime you hear a rule of thumb, especially when it comes to a trade secret or intellectual property, I would run in the other direction, because every valuation is facts and circumstances. And I'm not saying that because I make a living off charging people to value trade secrets. I mean, every asset, every company, every trade secret has some reasonable range of value, but that value is very facts and circumstances driven. So I would say keep away from rules of thumb. Keep emotions out of the thought process. We see that quite frequently, especially with early stage companies. This is, for a lot of people, this is their baby. This is what they have been developing, and they're emotionally tied to it, and they think it's worth some massive amount that may not be connected necessarily to reality. So you get misconceptions about valuation when emotions factor into it, when you start dealing with rules of thumb as well. And with trade secrets, understand what you're valuing and what you're not valuing. Are you including patented technology that you're somehow attaching to the trade secret that should be detached? How do the individual intangible assets interrelate with each other? Is it a customer relationship that's driving the value and the trade secret is just a small part of value? Or is it that the trade secret is really driving the entire process? So you have to have an understanding of, you look at a pie, how much of that pie is being contributed by the trade secret relative to, say, customer relationships or trade names. So misconceptions around valuation often come into play when you're dealing with emotional attachment. Have I erroneously attached other assets onto the trade secrets? And am I using some types of rules of thumb? Next slide, please. So I will pass it on to Christina, as this is not my area, and she can articulate the tax benefits of trade secrets.
Thanks, Phil. And I certainly am not going to bore everyone by turning this into a tax webinar, but I do want to point out a couple of things as we're going through and we're talking about trade secrets. Many companies use international tax planning as part of a healthy corporate tax strategy. And a lot of that centers around intellectual property. And trade secrets, just like any other intellectual property, can be one of the most valuable assets of a company. And with the use of proper tax planning, IP can be moved anywhere around the world. And so depending upon the current situation of a particular company, we can use intellectual property, trade secrets namely, to help drive down the worldwide effective tax rate of a company. So there's a lot of benefit out there once you are able to identify and value what your trade secret is. From a tax planning perspective, we can then use that asset for other benefits in terms of cash tax savings or effective tax rate savings around the world. One other thing to note is we move away from international tax planning and we focus just on the U.S. The U.S. has what we call a research and development tax credit, and it's designed to incentivize companies to create and to innovate while being in the U.S. It's to prevent technical jobs from moving overseas. As you'll remember, many years ago, we were all concerned about so many jobs leaving the U.S. and going to India or other jurisdictions. This credit is specifically designed to help incentivize companies to keep those jobs here. Any sort of development or ongoing maintenance of trade secrets or other intellectual property may qualify for a current year cash tax benefit in the U.S. So again, I'm not going to bore you guys with all the ins and outs, but I will say that, once you identify a trade secret, once you value a trade secret, once you pay attention to what goes into developing that trade secret, there are actually tax benefits out there that you could have significant and current benefits associated with them. And so with that, I'll turn it back over to you guys so you can get off the tax topic for a bit.
So what is this insurance all about? We've developed all these policies and procedures and processes around helping us help you, help me, help you identify, value, and protect these assets. But the insurance part of it is new. And it's a first-party policy, meaning there is no liability coverage under this policy at all. So if somebody sues you, don't look at this policy for coverage, period. However, if you believe that assets have gone missing, they have left the network, and a former employee or a competitor or whomever has either hacked in, there's a security breach involved, or they've just violated significantly their non-compete provisions, or many other factors that would ultimately result in the potential misappropriation of a critical trade secret asset. The policy is designed to cover that. And right now we can schedule up to 20 trade secret assets on the policy. We don't want to cover every single trade secret asset for a major organization. The reason for that is that not all of them will be as valuable as the top, your crown jewels of an organization. But also those are the ones that theoretically and practically you should be spending the most time and energy protecting. And so that's where we started. And, certainly something that we can talk about is a negotiating point. If a client comes to us and says, well, we have 23 that we want to schedule, I'm sure we could get that done. But right now we have $50 million roughly in capacity. We're not 100% sure exactly how much capacity we can get. Again, if somebody were to come to us and say, we want $62 million in coverage because Phil's done his valuation and we've got 7 trade secrets that total, $62 million in value, we would like to cover all of those, then, we could potentially do that. We just haven't been tasked to do that as of yet. So we like to use the $50 million number, but we really wanted to have meaningful capacity before we brought this to market. And I think most people would agree that $50 million is pretty meaningful capacity, considering there was zero before this product was developed. The limit is determined as a mutually agreeable number, the fair market value of the individual trade secret assets that could be compromised. And as Phil talked about earlier, we want to be careful in the planning process and during the valuation process to isolate and parse out different parts of a trade secret that might encompass other types of intellectual property, just to make sure that we know that if the trade secret is misappropriated, that we're not covering the full value of something that's already been patented, for example. But that's part of the process in terms of identifying the value of any given trade secret asset. And then the price, everybody asks about price, would be somewhere in the range of 3 to 8% rate online, meaning 3 to 8% of the limit that you purchase. depending upon a lot of factors, depending upon the threat environment in which your company lives, the types of assets that we're talking about. So defense contractors who are making stealth bombers and things like that would be much more risky to the threat of an attack, a cyber attack, for example, than somebody who's making hair dryers. Although hair dryers can be very cool. But that's just an example of how one might look at a much lower rate just based on the threat and the type of asset. But it also comes down to the security score and the defensibility score and the trade secret examiner. So there'll be a lot of different things that go into determining what the premium is when we look at this program. Next slide, please. By the way, while she's pulling up the next slide, I do want people to know we are going to take questions here in just a few minutes, but we do also have a podcast that is a Q&A where we answer frequently asked questions that we've gotten already on this process. It is the number 7 in our podcast series, Cover Your Assets. If you want to go listen to that, there's a lot more about pricing and the underwriting process and all of those types of things, but let's stick with this for the moment. So the coverage features are Insuring Agreement A, which, if you're familiar with cyber at all, is will look very familiar to you because it's breach response and recovery. So this is where we would involve a forensic investigation to determine the source and scope of a potential misappropriation of an asset, and try to figure out the who and how and why and where that asset or those assets are now, who's got them, what are they doing with them. And we're going to try to recover under this insuring agreement as well, put the genie back in the bottle, as we talked about earlier. And one of the great things about the federal statute, the TSA, is the ability to get this potential ex parte seizure order, which is something that allows you to seek recovery of that asset by looking at the personal technology devices of the employees who've left the organization or potentially go into that new organization, and do a search and seizure on a particular network, looking for keywords and all of those kinds of things to try to scrape that system and recapture those assets to the extent that everyone's happy and believes now that any future restraining order is going to hold and that you've got your assets back before they can do any real damage. If we're successful in that, then everybody's happy and that's all the policy pays for. It's still a lot of money, but it's all the policy pays for. If we're not successful for a myriad of potential reasons, like we don't know that the trade secret asset has gone missing, therefore you can't do the forensics on something if you don't know it's gone, then we pay the fair market value once ultimately it is determined that it was gone and it's too late and somebody's acted upon the theft of that trade secret to start their own company or to develop a competing product. We pay the fair market value of that asset as long as it was compromised by a security breach, which has a very broad definition under the policy form. And then Insuring Agreement C can be a little confusing, but Insuring Agreement C is essentially where we would pay litigation and enforcement expenses on behalf of the insured, even if we don't pay under Insuring Agreement B. And so what I mean by that is that if assets are misappropriated or stolen, but they were not stolen by a covered security breach under the policy form, then the policy could still pay because we will do the forensics to determine the source and scope of the disclosure. And if it was caused by something that is not a security breach, but we know who's got those assets and where they live and work now, we might still make the determination collectively that it makes sense to pursue that because we can, again, get potentially multiple damages on the back end and make the insured whole and make ourselves whole for any money that we've incurred. And so that's how the policy form works in a nutshell. Next slide.
So Mary,
I'm going to let Mark jump in here. Yep.
okay, all right. Well, the Uniform Trade Secrets Act has now been enacted in 49 out of 50 states. New York is the only holdout. But of course, now we have the Defend Trade Secrets Act of 2016, which encapsulates New York and every state, as long as the trade secret theft or misappropriation involves interstate commerce. Now, the Defend Trade Secrets Act of 2016, it does not preempt state law, but it provides lots of new remedies for the trade secret owner. The one that's critical is the ability to get an ex parte seizure order. And I wrote a law review article back in 2008 where I had advocated that there be amendments to the Economic Espionage Act of 1996 to add ex parte seizure provisions and to add a private civil cause of action for trade secret misappropriation. And that's what we now have in the Defend Trade Secrets Act. However, in order to be able to take advantage of the ex parte seizure provisions in the Defend Trade Secrets Act, you have to be able to come in on a moment's notice and establish that you in fact have a trade secret. And what the Trade Secret Examiner software platform provides is the ability to capture metadata about trade secrets in the company that's blockchain, so that you can go in forensically and establish the existence of a trade secret. And of course, you have all the remedies available under the federal statute that you do under the state statutes, and now you can bring both causes of action, which is injunctive relief, compensatory damages, and increased damages if the misappropriation is willful and malicious, which if your base compensatory damages, let's say, is 10 million or 20 million, let's take 20 million, but you're able to establish it was willful and malicious misappropriation, you get 2 times that, which is 40 million, added to the 20 million is 60 million in damages. And therefore, in effect, treble damages. You also have under the Economic Espionage Act, the Defend Trade Secrets Act, of 2016, is the scheduling of sections 1831 and 1832 from the Economic Espionage Act of 1996 as predicate acts for purposes of a RICO cause of action, which opens up the vista of third-party liability, all the way up to foreign governments. So that's the status of current legislation. Next slide. I want to discuss a recent decision by the First Circuit Court of Appeals, because I've been predicting that this is the way things are going to start to go in the federal courts. Now that we have the federal district courts and the federal appellate courts looking critically at trade secrets. Remember, before it was a state cause of action, and so you would only get into federal court if you could establish some sort of federal subject matter jurisdiction. For example, suing under a federal statute like the Computer Fraud and Abuse Act. This is a decision that everyone should take a look at, because this is what's happening. You have a company, TLS, that was a tax planning and consulting firm, and they sued a former employee for trade secret theft or trade secret misappropriation. His name was Rodriguez. And the activities go back all the way to 2012, and actually some of the events involved were into the year 2015. But essentially, TLS generated 2 types of reports. One was a capital preservation report called a CPR. The other was a strategy report. And eventually, through the discovery process and back and forth with interrogatories and document production requests and everything else, two trade secrets were alleged: the capital preservation report and the strategy report. TLS, though, could not identify the alleged trade secrets within the CPR, and TLS could not separate the alleged trade secrets with specificity from other information in the CPR, generally known in the trade. TLS also could not define the alleged trade secrets in the strategy report with specificity. Most of the information was public information, and TLS's claim that using promissory notes and security agreements which were generally known in the trade. So at the trial court level, we had cross motions for summary judgment. And the court granted summary judgment in favor of TLS for breach of non-disclosure agreements, which I'll come back to, but set the case down for a bench trial on whether the CPR and strategy reports constituted trade secrets that were misappropriated by Rodriguez and the new companies that he formed. And after the bench trial, the court found that these were in fact trade secrets and found evidence of misappropriation because these documents had been downloaded without authorization from Dropbox. And also there was other activity that indicated misuse of the strategy report. Each of these information vehicles, for example, the CPR was a 100-page document, and somewhere buried in there was the trade secrets. In the strategy report, it wasn't as big of a document, but it was in its 60th version. So it had been out there for many, many years. And the issue of whether the information was generally known to the public, even if it wasn't generally known to the public, the test is whether it's generally known in the trade. In any event, TLS filed an appeal, and the First Circuit, upon appeal, found that neither of these compilations of information qualified as trade secrets. And if you look at the decision in the oral argument, the court asked, you know, what the trade secrets were, and counsel could not, in the oral argument, identify the trade secrets. So the court reversed and remanded for judgment in favor of the defendants. On the non-disclosure agreement, which was also subject to the appeal, the disclosure agreement basically said, in essence, that any information that these former employees were exposed to while working for TLS constitutes proprietary confidential information that may not be disclosed or used for their own benefit or the benefit of others after the termination of employment. And the court for the First Circuit, applying the law of Puerto Rico, because it's involved Puerto Rico and Puerto Rico's version of the Uniform Trade Secrets Act, you know, basically slammed that and said that's overbroad. You have to take into consideration the general knowledge, skills, and experience of former employees, and you have to tailor these agreements to protect information that qualifies as a trade secret, but not any information that they've been exposed to, because they're entitled to use that as part of their general knowledge, skills, and experience. So as a matter of law, they threw that out. So here we are in 2020. The decision was issued on July 21st, 2020.
Gail, let's go to the next slide. Sorry, Mark. Let's go to the next slide.
Okay.
Keep talking.
Okay. So again, this was the what I've described: the trade secret claims, the alleged CPR trade secret, the alleged strategy trade secret, and the breach of contract claims. And so I've covered that.
Yep. Next slide.
So how would have the Crown Jewel, how would CJP have changed this outcome? Well, this software platform provides for the identification and predetermination of what the trade secrets are and how defensible they are. And this eliminates the central issue which arises in many of these misappropriation cases, virtually all of them, including the one I just covered, when in trying to define with particularity what the trade secrets are. And under the Trade Secret Examiner platform, we would have isolated publicly known assets and separated them from the rest to get at the value of the trade secrets beforehand. We would have determined during the underwriting process, which includes a review of the employment agreements for non-compete, the whistleblower, and other provisions that come into play with the Defend Trade Secrets Act, whether or not those provisions were acceptable. We would have had an exit interview with the former employee that ended with an affidavit that the person did not take documents considered to be trade secrets by the company. We would have everything in place for ex parte seizure using blockchain evidence from the TSC software platform. And if not successful, then we would be able to pursue damages, including exemplary or increased damages for things that were in fact trade secrets and misappropriated.
And I think the point here, Mark, thank you for that, and we'll take questions now, but I think the point being that, you know, if you read JD Supra and all kinds of other periodicals and case law that's coming out on a regular basis now, you'll see common themes over and over, that the client didn't pre-identify things as trade secrets, that they were overly broad potentially in labeling everything as proprietary and confidential, that their non-competes provisions were too broad, all of those types of things, and frankly that they hadn't identified and valued something specifically as a trade secret beforehand. But this whole process is designed to take that off the table. And I recognize that we're running short on time, but I do want to open it up for a couple of questions. If people have some, I know Lindsay was sharing something with me that asked about if the 3 to 8% premium was an annual premium. The answer to that is yes. And you know, but you think about, it seems maybe a little bit expensive at first blush, but if you think about how most policies work, they have to be adjusted on the back end. And it's very unusual in a lot of circumstances for you to get what you fully demanded from an insurance company, or in litigation, things can drag out for years on the third party side of things. So what we're doing is saying this is an agreed value policy. The adjustment process should be short and sweet. And frankly, if we pay a loss, it's almost certainly going to be the full limit of a trade secret asset. And so that has to be accounted for in the pricing. So that was one question. Somebody else asked if there was coverage if your company is accused of misappropriating somebody else's trade secret. I think I already answered that. To my knowledge, you might find some minimal coverage under a private company D&O or EPL policy, some defense expense cover for the most part, but generally speaking, that is typically not covered under most policies. And then another question that was coming in was about, are there insurance policies, standalone, I guess, insurance policies that pay for just the outgoing litigation on the back end, which in our case would be essentially insuring agreement fee, C, or subrogation expenses under this policy. I am not aware of any. I know that there is a patent enforcement or an intellectual property enforcement policy that you can purchase out of a company in Kentucky, if I'm not mistaken, but I believe that it's only $5 million in limits, and so it's not particularly meaningful, I don't think, in terms of the capacity that you can purchase. Does anybody else have any other questions? Oh, I have another question here. How does the software determine what is a protected trade secret and what is not? Mark, I'll let you answer that question.
Well, the alleged information asset is evaluated with the 6-factor litmus test that essentially is used now by the appellate courts and trial courts all over the country. The extent to which information is known outside the company, the extent to which information is known inside the company, the time, effort, and money expended to develop the information, the level of security to protect it, the value of the information to the company, and if it were to get into the hands of competitors, and the difficulty to reverse engineer it. This creates a defendability factor score, which opens up your ability to classify the trade secret assets based upon the scoring. And also there's a security factor score that's calculated. So this, and again, this involves the metadata. I can't overemphasize that trade secrets are not actually entered into the system or collected in any way. This is like a card catalog in a library that tells you that a book exists and the location of it. It's just the metadata about the trade secret. But with that, with this scoring, we can determine the most valuable trade secret assets based on the score. So we're going to insure up to 20 corporate jewel assets. These are going to be the top 20 assets of the company. And that'll be, and that will flush itself out once we see the scores, because the 6-factor test is the litmus test to determine whether an information asset qualifies as a trade secret. And then looking at the security score, we'll have that whole package ready for the third-party valuation that we discussed to make the final determination for insurance.
Thank you. I have time. I'm just going to answer one more question. Somebody else asked if counsel was pre-selected for enforcement actions on the back end, I believe. And that's where we've tapped Mark and his expertise to help sort of quarterback that potential litigation or enforcement for us. But, you know, certainly Mark would engage local counsel wherever, you know, at various jurisdictions around the country or around the world where we need help. Mark, I don't know if you have another answer for that.
No, I mean, I have a list of go-to firms that I've worked with over the years, but certainly we would, you know, that's part of the strategy, is to have a very effective litigation teams and connected all over the world so we can get the full benefit of this policy.
Absolutely. And I think we're actually over our time limit a little bit here by 5 minutes according to my clock, but we really appreciate everybody's time, and we hope that everyone will follow us on all of our social media. We do have a 7-series podcast that's available for people to listen to, and by the way, it was just named as the second best trade secret podcast on the web. So we're excited about that. We have another kind of 101 webinar that's available on YouTube that's an hour and is more kind of basic in nature if you wanted to check that out, but certainly reach out to us with any questions. And again, thanks for your time.